What's up, everybody, and welcome back into another episode here, breaking down some Kohberger documents that were filed over the last week. And his team wants another stay. They are saying there is another issue potentially with the grand jury proceedings, not just that they used the wrong burden of proof, but there were other problems. And today we're going to talk about potentially what those other problems are. We are going to read through this second motion to stay. And to help me do that today, I am bringing on my dad. Hello, Dad. How are you?
Hey, how are you?
I am doing well. Let's jump into this document. You guys hit that like button. If you haven't already, for bringing Big George on, hit that like button for breaking down these Kohberger docs. If this is still a case you all are interested in, and we will continue to cover it. So, first things first, second motion to stay proceedings. We know they already had another one, and the judge stayed the proceedings 37 days, extending the defendant's speedy trial period. The defendant agreed to it as not a issue he can raise when they pass the 6-month mark. So that's kind of where we stand for now on that. The state has a problem with it. The state has kind of objected to the judge using it as kind of a partial waiver of speedy trial, even though that's not what the defense said. Let's see if they get another one, because it seems like that's exactly what they're asking for, which the state said would happen. So through his attorneys, he says Idaho Code 2213 provides for a stay of proceedings upon verified allegations of failure of Title II of the Idaho Code. Filed in conjunction with this motion, but under seal, is a sworn affidavit alleging a failure of Title II of the Idaho Code. So something has been filed under seal in this case, which is an affidavit. Dad, what do you think's in that affidavit?
Well, affidavit, I'll bet that she saw something or talked to a potential grand juror or talked to a grand juror, asked that grand juror some questions about the questionnaire they filled out. Maybe got some information from that grand juror that says, well, no, I don't remember that question on the questionnaire, or I didn't send it in 10 days ahead of time, or she went through the list here that you can see in the second paragraph.
Well, we're going to get to the list, but
if she went through that with a grand juror and she's doing an affidavit regarding that.
So basically, the affidavit's under seal, so we don't know exactly what's in it. But based on what we're about to read, the affidavit attached that is under seal is the specific problem that the defense found when they went through all the grand jury testimony, grand jury materials, questionnaires, jury selection, jury answers. They have all of that now. They've gone through all of that, and they have filed the issue they have found under seal. So what is that issue? What is it in the groupings of? Well, let's take a look at the rest of the motion here to give us an idea as to what they focused on the second time around. Title II provides statutory authority and requirement for convening trial juries or grand juries. Mr. Kohberger alleges failure of full compliance with Idaho Code 2208. This statute states that individuals must be randomly drawn from a county jury list, and that the jury commissioner shall draw a requisite number of qualified jurors for one or more panels or for a grand jury. The statute further requires, upon receipt of the direction and in a manner prescribed by the court, the jury commission shall publicly draw at random by use of a manual, mechanical, or automated system from the county jury list the number of prospective jurors specified. The number of potential jurors appearing for a potential selection impacted the seating of grand jury that heard the case. Based upon review of the grand jury convening process, apparent failure occurred. So based on that paragraph, what are some of the issues that could be in this affidavit that they're going to argue necessitates another stay?
Well, I mean, we're obviously speculating.
Yeah.
But we're talking about, for instance, they have to be selected at random using a manual, mechanical, or automated system. Well, let's just say they used a computer. And let's say they're arguing that a computer is not an automated system because it's not this or it's not that. Or let's say they had some guy sitting in a back room randomly pulling names out of a hat. Is that a manual or a mechanical system? I don't know. But they could throw in all sorts of little technical differences and saying, look, the statute didn't say computers. The statute didn't say draw names out of a hat. The statute didn't say exactly what it is this county particularly did with the list. The statute they can go through the list. And another interesting thing that they're not really pinning themselves down with, when they say the process had an apparent failure occurred. So they don't even say that a failure did occur. They're saying it was an apparent failure. So they're trying to hedge their bets. And I think they're trying to walk a tightrope so that they don't get caught lying in this motion. And they say it's apparent, not that it actually happened.
Idaho Code 22083 requires that the qualification questionnaire from a form must be completed and returned to the clerk or the jury commissioner within 10 days from the date of mailing. The qualification questionnaire form shall elicit the name, address, or residence and age of the prospective juror, and whether the prospective juror A is a citizen of the United States and a resident of the county, B is able to read, speak, and understand the English language, C has any disability impairing his capacity to render satisfactory jury service, and D has lost the right to serve on a jury because of a felony criminal conviction as provided by Section 3, Article 6 of the Constitution of the state of Idaho, and who has not been restored to the rights of citizenship pursuant to Section 18310 Idaho Code or other applicable law. The qualification questionnaire form shall contain the prospective juror's declaration that his responses are true to the best of his knowledge, and his acknowledgement that a willful misrepresentation of a material fact may be punished as a misdemeanor. Based upon review of the grand jury materials and process, it appears a failure has occurred. So this one specifically is with qualifications of the jury. Either they weren't from this county, they weren't able to read or speak or understand the English language, they have a disability impairing their capacity to render satisfactory service, or a felon got on the grand jury. So this one is more obvious as to what the problem could have been. A juror got on this grand jury, they were not qualified to be on this grand jury, and they rendered this verdict.
Well, there could be another angle on this.
Okay.
It could be that they're qualified, but the questionnaire was wrong. Mm-hmm. So you got a qualified juror, but the clerk sent out a questionnaire that did not have all these questions.
10 days.
Right. Or it could be the 10 days, because these two paragraphs have two totally different angles that they're coming after this grand jury. Number one, you have the selection process. That's the first paragraph. And the second paragraph is the qualifications. Mm-hmm. So they're attacking everything, which we understand that they're going to do. But again, this one could be a questionnaire problem. It could be a 10-day problem, or it could actually be a disqualified juror problem.
And it makes sense that the affidavit was filed under seal because the grand jury names and their identification has all been under seal the entire time. So if they were going to give an affidavit that says John Smith was disqualified because he was a felon, that has to be under seal and confidential, because they are not letting the names of the grand jurors out. And I don't expect that to change. So we're never probably going to see this affidavit, maybe after the case is over, but we're never going to see this affidavit as part of this litigation. But that makes sense as to why it is filed under seal. And this is giving some examples of what potentially could have gone wrong. And again, based on that last sentence, based upon review of the grand jury materials. So they have received them, reviewed them, and they have another issue. Further, other irregularity exists within the grand jury process, and further investigation is necessary to determine the impact, if any, in the convening of this grand jury. Because of the apparent failure of compliance with Title II, Mr. Kohberger respectfully requests a stay of proceedings while further investigating the opportunity to be heard occurs. So what do you think about that? Requesting another stay to do further investigation into these grand jury proceedings, knowing that the judge has already granted one stay of the speedy trial period, 37 days. They have not continued the trial. They have not stayed depositions and motions and everything going on in the case. They are only staying the tolling of the speedy trial period. So what do you think about the fact that they're asking for yet another stay?
Well, it all depends on how careful this judge is going to be in trying to avoid any appellate issues. And it could be that this judge is going to say to himself, look, there's nothing here. There's never been a grand jury that's been thrown out. There's never been a grand jury indictment thrown out for these technicalities. However, in order to avoid this issue as for appellate reasons, I'll go ahead and give them some time to investigate this and see what they can turn up. Again, it's how careful and conservative that judge is going to be.
You're not saying that that's never happened. You're saying the judge may think that that's never happened in this county.
I have never seen a jury totally thrown out because of a technical, not, again, I'm saying they're all qualified, but I'm saying, let's say they used a computer versus, the technical aspects of this versus a disqualified juror. Those are two different ways to look at this. Disqualified grand juror, yes, that's an issue.
Right. That's what I'm saying.
Yeah. And
because there
in
are
fact,
multiple issues here, it
right,
absolutely could be thrown out if he finds one of these issues. You're just saying one of the technicalities, like, it was turned in 11 days later instead of 10 days later. They're not going to redo the whole process because of that.
right. And so I think that's what I'm saying. This judge, if he wants to be conservative and careful, he's going to give them a stay in order to investigate this.
So one of the big arguments back and forth between the state and the defense is whether or not this stay that's already occurred is a full waiver. What's your experience as far as defendants who are demanding speedy trial, but also asking for stays because of delays by the state? They were saying the delay or the state was blocking or objecting to certain grand jury materials. Judge and the state, they ended up agreeing, okay, you can get basically everything. And because of that, they allowed some extra time. What are your thoughts around that? Whether or not it's fair to grant stays that seem like partial waivers of speedy trial, but they don't actually waive the speedy trial. They're still demanding it. What are your thoughts on that?
It happens all the time. It's very regular. The appellate courts recognize the fact that you can give a 15-day and then speedy trial starts running again. In this case, I think it was 37?
Yeah, so far.
Right? So 37 days. After the 37 days, it starts running again. So it's very common. And I think it's going to happen in this case again, if this judge is being very careful to make sure he doesn't have an appellate issue.
And I think the judge could also just say, we built in enough time for you to investigate this issue in the 37-day extension that we've already given or stay that we've already given. I think that's possible. But in abundance of caution, you always want to give the defendant every benefit of the doubt you can, again, to prevent any major appellate issues from popping up. But to me, this doesn't seem like some smoking gun or something that they found in the grand jury proceedings, number one. Number two, it also doesn't seem like Kohberger's team is worried about the judge giving a stay and having a speedy trial issue, since in the last one, the judge's order was very specific, was very, very particular about how the defense agrees this is not a waiver of speedy trial, but they also will not file a motion to dismiss the grand jury indictment for lack of speedy trial because they're agreeing on this 37-day stay. Well, so as long as it's documented appropriately.
And that's the problem, is that affidavit, is there a basis for this stay? And we really don't know. Again, if they have a specific juror that they're pointing to and saying, this juror is not qualified, this juror didn't fill it out right, this juror lied on the form, then the judge can have a hearing, probably in camera. He's going to have that hearing and question that juror to see if there's a basis for what the defense is saying. If they have no basis, if even the affidavit, if you assume everything in the affidavit is true, doesn't give them a basis, I don't think the judge is going to grant it. There's got to be something in that affidavit that, if true, would give them a basis for the stay.
Yeah, I really think that in this situation, as we continue to look at this case, this is something that the defense is going to continue to try to do to gain more time so that they can prepare for this trial, because the state is trying to hold their feet to the fire basically with this October date or with this 6-month speedy trial period. The defense continues to find issues or things they believe are issues, and they need more time to investigate, especially with the grand jury and the delay in getting them the grand jury documents. So it seems like, again, I've felt like it's going to be impossible for this case to go to trial on October 2nd.
Well, I agree with you.
Yeah. So, I mean, but to answer the ultimate question, let's say there was a disqualified juror on there. Let's say there was a felon that got on there that should have been able to render a grand jury indictment. Have you ever seen cases that grand jury indictments are dismissed based on some kind of technicality or some, disqualified juror, and then it goes back and now they're not indicted because they changed out that one jury or juror?
Never. In fact, I've seen cases where they throw it out, and on the same day, they take it to a grand jury that's sitting and they get a new indictment, and they don't release the guy because the indictment's thrown out. He still stays in jail. So this is just a delaying tactic. Frankly, it's not going to matter in the long run. It's not going to make a difference.
I mean, the only thing that could matter, I guess, is it could give him a new 6-month speedy trial period if it gets dismissed and he's reindicted, and it starts the clock from that arraignment after that indictment or preliminary hearing. But yeah, at the end of the day, if any of these arguments work and the grand jury indictment gets dismissed, nothing we have seen so far would make us think that a grand jury would come up with a different verdict being presented with the same facts, even under a different burden potentially, if this was done again in the future. And I think that's the ultimate question a lot of people have.
And you can't, people sit out there and talk about playing the game in the process. You cannot blame these lawyers. A man's life is at stake, and you want to make sure that, every avenue is, before you take a man's life, every avenue should be tried. And so I don't blame these lawyers for doing everything they can to try to protect his constitutional rights, because again, they have filed for a death penalty in this case. So a man's life is at stake.
Yeah, I agree, but I also do think there is a line. I'm not sure if we would say the line is in the same spot, but I think you would too. You don't file frivolous motions that are going to lose,
frivolous, no.
Or make arguments that are not even worth making, not even protecting the record, not even appellate issue if you win. But yeah, I agree. Obviously, death is different. We've talked about it a bunch, and we will continue to as we go along in this case. Dad, thank you so much for coming on. Sure. Hit that like button on the way out, everybody. Let me know what you thought in the comments. I appreciate everybody joining me. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to The Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.